It was a tough loss for Coyle. Even though he made $5 million in 5 years, his lawyer could not get this case dismissed. In fact, it was denied by the judge. And in short, this is what the judge said. An actual controversy has arisen between Tove. Remember, Tove is the company that hired DW. And according to Tove, they own all the work of DW. And Coyle's lawyer did pretty much everything he could, which I thought he was going to be successful in saying, hey, your problem is with DW. If you're missing money, you got to go through DW, because that's who Coyle paid. And the defendants regarding the parties' respective rights into any and all copyrights derived from DW's creative contributions to the server, which we know he set up to pay priority, which is allow Coyle to make millions in all monies generated from the exploitation thereof, including without limitation, whether a permanent and irrevocable license for the defendants to continue exploiting or otherwise utilizing such contributions was ever granted to the defendants. So the issue is, does Coyle have a irrevocable perpetual license? Well, the court seem to think he doesn't, hence they're going to trial. And I could play devil's advocate and say, hey, the judge made the right call, because there's truly no paperwork involved. Like, there's no contract, which is the craziest thing to me, right? To me, that is beyond me. Y'all are making millions and there's no paperwork, all off a handshake agreement. And I imagine Coyle's not doing any business like that ever again. I'm sure he's been advised not to do that. Well, we do have an update. What's the update? This was filed 4/17/2024, and I kind of knew this a while ago, but it is what it is. We have a trial date. You're like, God damn. Trial date. Trial date is set for July 16th, 2024. I said it was a small update, but this is when the trial is actually scheduled to start, guys. It's actually scheduled to start July 16th, 2024. Now, look, here's the thing, and we're going to go through it. They can settle this before the trial date. I think it was, I kid you not, I think it was all over $150,000. I think so. But now with this leverage and it going to a trial, maybe it could be about a bit more for legal fees and potential ownership of the server. But here's the thing, right? They agreed to this. All right, so stipulation to continue trial and trial deadlines. All right, now comes both basically Tove and Nopixel. All right, they both come in here together. This is a positive sign. This is a step in the right direction. We know the lawsuit was filed in July 7th. The denial wasn't filed until February 14th. The court denied Coyle's motion to dismiss the first amended complaint. March 18th, 2024, they exchanged their initial disclosures, okay? March 26th, new case status conference was held, and the court set a trial date for July 16th, 2024. So it is going to trial. It's on schedule to go to trial. But now we get into the discovery. Defendants. March 29th, defendants served written discovery on plaintiff, as well as the plaintiff served written discovery on the defendants on April 8th. Now here is something that's going to be interesting. Okay. Plaintiffs has obtained an expert to which defendants have not yet agreed, but are considering. So an expert is anyone like certified to validate information. Think of an expert as, in layman's terms, someone who has the credentials to validate or invalidate information. In like my previous job, maybe I was considered an expert witness to my findings, things like that. Whereas on April 15th, the parties met and conferred on how the source code will be reviewed. Oh, shit. The source code. Now, the source code, guys, I'm not a developer or anything like that, but that is the backbone of, I believe, Nopixel, right? The source code for all my developers in there. So they conferred on how the source code will be reviewed, which defendants are also considering. So, hey, they said, hey, we want to review the source code like this. Defendants is like, I don't know. Now, here's the thing, right? If they can't agree, then the court has to get involved and make the decision. And chances are with these civil lawsuits, you really don't want the courts to make decisions unless y'all are really at odds. So they filed a protective order, which I do have a copy of the protective order, and we can briefly go through it, but it's very legal and technical, where I highlighted some points, okay? The plaintiff's expert will need at least 45 days from the dates the defendants agreed to accept his designation to review the source code and draft a report. Now, here's the thing, guys. If someone is suing you and they say, hey, we are suing you, and here's our expert. We have our expert that's going to review the code. Do you, as the defendant, as the person getting sued, choose their expert? I don't know. Now, in my divorce, where we're supposed to go to mediation for things, she's supposed to provide 3 mediators and I pick one. That didn't happen, so we're going to court. But anywho, what do you guys think about that? So 45 days just to review it. And lastly, they are asking, whereas the parties have worked diligently to advance this case at best as possible, have therefore agreed to continue the trial in all related deadlines by at least 90 days. So they're like, look, I know we got this trial date, but can we get this 90-day extension? 90 days. 90 days from April, which would still put it at July. And, you know, both attorneys signed. Larry Zerner, like, shout out to Larry Zerner, man. Like, I'm still in disbelief that it didn't go Larry Zerner's way. But, you know, that's the courts for you. Now, here is the protective order that they filed. And it's only a couple things to note. You're like, what do we need to know? There is a good cause statement. All right. But gosh, the limitations, we're going to get to the purpose and limitations. This is basically to outline like discovery and how things are going to go. But it's mostly to protect some things. If you're Coil and you're about to run into this lawsuit that's potentially about to put trade secrets out there in source code material, you kind of want to protect it. OK, so this is not like something out of the norm. Good cause statement. This action is likely to involve commercial, financial, proprietary, creative, and developmental content and other confidential and or proprietary information with special protection from public disclosure. Now, look, public disclosure is me. They're like, look, man, it's this guy named Henry. He's covering the lawsuit. Anything y'all put on the fucking docket, he's going to pay for. He's going to request and put that shit online. The last thing we need is him putting our source code online. Now, I probably wouldn't do it. God forbid they will put their source code like it was to get out there. And I would be like, put it out there. I don't think I would. It's certain things I just protect. But, you know, they want to take that decision out of the public's hands. And I actually commend them on this. OK, yeah, he don't want us making our own RP server, basically carbon copying his blueprint. Form, use, or any purpose other than prosecution of this action is warranted. Such confidential proprietary materials and information consist of. So look, this is everything that they're about to disclose. Other things, confidential business or financial information. So you'll get to see like, you know, who's paying what or how much money they're making from each segment of Nopixel. Information regarding confidential business practices, other confidential research, development, commercial information, including information implicating the rights of third parties. So rights of third parties is probably like Rockstar, right? It'll be a third party. Information otherwise generally unavailable to the public or which may be privileged or otherwise protected from disclosure under state and federal statutes, rules, case decisions, and common law. Now, we don't need to read all this. We just need to get to this stuff, right? Or to the highlighted portion. So they give you the definition. I believe expert is a definition under here, so we can talk about that. But confidential information. What is confidential? Confidential information or items is information regardless of how it's generated, stored, or maintained, or tangible things that qualify for protection. So they want to have the ability to label things confidential, which is sure. But then they have this second layer of confidentiality, where it's highly confidential, where this is attorney's eyes only. This is the shit like, hey, we only want the lawyers to look at this shit. We definitely don't want Henry ass looking at it. And we don't want members of the public. And we definitely probably don't want DW ass looking at it. So what do they say about highly confidential? Okay. And look, the third parties, hey, not just Rockstar, but the streamers that play on the server as well. And potential sponsorships, partner, etc. Very, very, very good. Yeah, those are third parties too. But if to be honest, if I'm looking at this case and they putting out some shit, I want to see what they got cooking up for GTA 6. I want to see what's up with that. I want to see what the RP release date schedule is like for GTA 6. Is it going to launch with the game? Is it going to launch, 6 months after the game is launched so people had a chance to play it? I would want to look at all that shit. And this is why I say lawsuits are tricky, because they put so much of your public business out there in the world, so you have to protect it. So that's why they filed this protective order. So highly confidential is pretty much more of the same. Information or items, the disclosure of which to another party or non-party would create substantial risk of serious harm that could not be avoided by less restrictive means. So in other words, if this shit get out, it could damage our server. It could hurt business relationships. It could hurt a bunch of things. Now look, they got all these other definitions in here, but expert. Here's the person that they have to agree on. Expert, a person with specialized knowledge or experience in a matter pertinent to the litigation who has been retained by a party or its counsel to serve as an expert witness or as a consultant on this action. Now look, you have different ways to choose an expert, and some people bring in two. You hire your expert, you pay your expert, I'll bring in my expert, and maybe we'll meet in the middle. Maybe their experts will agree. You really never know. I mean, but this is the order of protection, protected material, anything disclosure or discovery materials that is designated as confidential, highly confidential, in attorney's eyes only. But this is where we're at. This is where we at, guys. This is a real lawsuit. This shit is likely going to go to trial if they can't sort it out within the 90 days that they asked for. And like I said, it's 15 pages of legalese, and they just keeps reiterating pretty much anything that they submit is going to be highly confidential. Highly confidential. And, being that this case is so public and it's overseeing so much, I doubt that they'll say, totally like, no, it's not confidential. The public should be aware of it. Like, no, to be honest, I think they both want this over. And that's just what it is. They both want it done with. They both wanted this behind us. But people don't agree. That's what the courts are for people who don't agree. If Coil want to keep perpetuating things I'm not reading, guys, it's just more legalese, but I want you guys to see the whole document. So if somebody from the Nopixel, the RP Nopixel community want to read all this stuff and go through it, they can. So, but the biggest thing is right here. It came right here. They asked for a 90-day extension, and they want to hire their own expert, and they're going to be looking at the source code. Now, people told me that Coil stopped using the source code for paid priority. I guess they're going to figure that out in court, and how long he did use it for, and how much money he potentially does owe Tove. So what do you guys think of this small update? So we probably won't have an update until either it'll be settled before the trial date, which is in July 19th, which is approximately 16, sorry. Or we go to trial and then we'll just see who the judge decides. We'll see what the outcome is. But let me know what you think. I'll see you in the next video. Peace. All right.